So what is the process for handling a serious or catastrophic injury trucking case? Hi, I'm Dan Pruitt, and for the next few minutes, I'd like to go through the process with you. The first moments after a serious collision on the highway are often some of the most important. Most trucking companies have a legal team on rapid response. It's not uncommon for a lawyer to come out to the scene to assist the truck driver in preparing a statement for the highway department. So the first two parts of the process involve, number one, the investigation of the accident, and number two, the preservation of evidence. This time frame would last for the first moments after the accident until potentially several days or weeks. We should have an expert go out to the scene and reconstruct what happened to determine what the speed of the truck was, what direction was he traveling, did he apply his brakes. The physical evidence on the roadway may give us vital clues, but it may only be available if we can get the expert out within a few days of the collision. In addition, we need to have an expert go and inspect the truck, take photographs of the damage to the truck, and check out all of the different aspects under the Federal Motor Carrier Act that the trucking company must do to have a truck on the roadway. Did they comply or did they fail? In addition, we would obtain the inspection reports from the Department of Transportation. The second phase is preservation of evidence. During this time frame, the lawyer will send a letter out to the trucking company and to the truck driver demanding that they preserve certain vital evidence. If we don't direct them to save the evidence, they are not required to keep it forever. It may disappear in a matter of days, weeks, or months unless important action is taken on your behalf. One important aspect is for the expert to go and download the electronic data from the onboard computers. The truck will tell us all sorts of information about the speed, the direction, the application of brakes, and other vital information. In addition, when did the truck driver rest? Is the truck driver fatigued? The next step is to determine what theories of responsibility we should use to litigate or to resolve the case on our client's behalf. That's when we look at what did the driver do that we would call negligent or even reckless? What did the company do? Did they hire an unsafe driver from the beginning, or did they fail to train him so that he would be safe? Or did they keep him long after they realized he was unsafe? Do we need to consider going and having theories of responsibility against brokers and shippers or even insurance companies? This is an important time for us to identify all the sources of insurance, because when our clients have been catastrophically injured, their damages may be $10 million, $20 million, or even more in seriously catastrophic cases. Step 4 would be to use the discovery process during litigation to get additional information from the trucking company to help us establish all the different elements of the case. We can get the personnel file for the truck driver. We can get information concerning any training materials that he was provided. We can learn, did they provide in-service training or not? Finally, we would have our expert go through all this information that we received during what I call the discovery phase of the lawsuit in order to determine if we have a case for punitive damages. All of these parts of the process are complex but very important. If you have been injured by a commercial driver, I'd be happy to talk with you personally and to go over each one of these aspects of your case to determine what we can do to help. Call us today.